Hello friends, this is part 2. In part 1, we reviewed Webster versus Reproductive Health Services, where Adventist lawyers from the church headquarters appealed to the Supreme Court of the United States to block abortion restrictions. That is to say that the government of Missouri wanted to stop the killing of children, but Adventist lawyers representing the church argued to keep it legal. In part 1, we looked at many of the illogical, terrible arguments that have greatly stained the reputation of this church, but I saved the worst for part 2. There were many individuals, organizations, and many churches that filed amicus briefs in this case, but of all of them, the Adventist attorneys specifically attacked the Catholics because, as the Adventists argued, the belief that the unborn children are human beings from conception is purely theological or inherently theological, and therefore seeking to stop the killing of children because one believes that the unborn human beings are unborn human beings, then this would be a violation of church and state. Notice here on page 27, the Adventist attorneys wrote, "The briefs of Catholics United for Life and Knights of Columbus focus on what they perceive to have been the prevailing mood of the nation and the existing abortion laws at the time the 14th Amendment was adopted. Then, ipse dixit, they engraft on the 14th Amendment the concept that its protection of persons includes a fetus." And notice this sentence right here. This argument ignores the what? Ignores the fact that the common law and the prevailing view at the time of the adoption of our Constitution and the Bill of Rights fails. It fails to support any such notion. This is a very important paragraph, so let's take a few moments to step through this. This was a very important, Webster was a really big case. There were a record 85 amicus briefs filed in this case, but the Adventists hammered on the Catholics United and Knights of Columbus, which is, if you don't know, a Catholic fraternal organization. They focus on what they perceive to have been the prevailing mood of the nation and existing abortion laws at the time of the 14th Amendment's adoption. So they are tacitly admitting, that there was an anti-abortion mood and anti-abortion legislation in the end of the 19th century. Ipse dixit is an assertion without proof or a dogmatic expression of opinion. The Adventist attorneys say, well, nevertheless, ipse dixit, the Catholics engraft on the 14th Amendment the concept that it applies to unborn children. Now take a moment to appreciate what is being said. These Catholics and other organizations provided undeniable, well-known, easily verifiable evidence that at the time of the 14th Amendment in the late 19th century, there were nationwide efforts to protect unborn children and make abortion illegal. The Adventist attorneys tacitly admit this, but then amazingly, they then accuse the Catholics of imposing on the 14th Amendment protection for the unborn when the Adventists themselves, out of their own mouth, admitted that the very people who supported the passing of the 14th Amendment were simultaneously passing unanimous legislation to protect unborn children. So, in other words, in the late 19th century, there was a huge wave of anti-abortion legislation in the United States. Laws were passed in all states without any resistance or controversy. The nation was horribly divided on slavery, but not at all divided on abortion. Everyone approved anti-abortion legislation, and these very same people that made abortion legal, these were the same people that also passed the 14th Amendment. And the Catholics argue, hey, look, the same people who protected the unborn are the same people who passed the 14th Amendment. Therefore, they saw the unborn as living human beings because they specifically said so in their anti-abortion legislation. These Adventist attorneys, however, totally twist what is going on and accuse the Catholics of making unfounded dogmatic claims. What is really, really bad, don't miss this, is this statement right here. This argument ignored the what? Ignores the fact that the common law and prevailing view at the time of the adoption of our what? Our Constitution and Bill of Rights fails to support any such notion. This is incredibly false and untrue and terribly misleading because the rise of abortion and anti-abortion legislation in the 19th century was a result of changes in technology. The key word is technology. Developments in science and medicine led not only to the discovery of the human ovum in 1827, but also new medical procedures and technology that made surgical operations and therefore abortion safer for the mother. Prior to this time, abortion was tantamount to suicide. It was because abortion was now safer, and also because of the understanding that life begins at conception, that the American Medical Association began the now well-known and famous Physicians' Crusade against abortion, so that by 1900 it was outlawed in every state. To understand how deceptive this is, the Adventists accused the Catholics of being dogmatic and ignoring, quote, facts, but they do so by moving the goalpost and going back to the Constitution and Bill of Rights when no such technology was available. So the 14th Amendment was ratified in 1868, but the Constitution and Bill of Rights were ratified 80 years earlier in 1788 and 1791. The Adventist attorneys arrogantly argue that the Catholics, quote, ignored the fact that the common law at this time fails to support any such notion. Over the years, there have been several people who have published research on this specific question, but the most well-known is law professor Joseph Dellapenna. Remember that name. You're not going to read anything about the history of abortion in common law without seeing some reference to Dellapenna. His name is everywhere because he has published research of abortion being charged as a crime in common law as far back as the 13th century, and also that abortion was considered a crime at common law in the USA at the very time that settlement of the American colonies was about to begin. There are cases prosecuted for abortion over 100 years before the Constitution was ratified. The Adventists argued that it was a fact that abortion was not a crime at common law, but what makes this so bad is, get this, both Catholics United and Knights of Columbus cited guess who in their brief? That's right, Joseph Dellapenna. They had based their claims that the unborn were considered living human beings on documented historical evidence. The Adventists had read their papers. They went through their words with a fine-tooth comb. They saw the multiple references to Dellapenna's evidence, and shockingly, they totally ignored this evidence and then accused the Catholics of ignoring facts, when that is precisely what the Adventists did. And if that's not bad enough, Dellapenna is such an expert on this issue that, as you see right here, he himself also filed an amicus brief on this exact same case with all of the evidence. These Adventist attorneys representing the church had all of the facts and evidence before them, but they rejected it all in order to get before the Supreme Court and accuse and publicly slander other churches, and now it is a matter of permanent public record. To you, the viewer watching this video, I'd like to ask you a question. How do you think this history affects the mission and reputation of our church? And how do you think this history affects our relationship to God? Do you think any of this history even matters to God? Yes or no? Why or why not? Please let me know by leaving your comments down below. Thank you for watching.